Welcome everybody to the Labor and Employment Law section case update. Today we're going to discuss the cases published during the month of August 2025. I am Javier Rivera Carbone, your host, workplace attorney investigator. Today I'm joined by George Bean, who's a workplace attorney investigator and concentrates his practice mostly representing employees and conducting workplace investigations. We had a busy September, and George was kind enough to last minute make himself available to the summary. So thank you, George, and thank you to the law firm of Payne and Fears for preparing the summaries that you received together with the link to this video. We're going to be making reference to the materials by page number. So we are going to look at the summaries prepared by Payne and Fears, and looking at page 2, George, you're going to discuss a case on that page.
Okay, we're starting with Muñoz versus Regents of University of California. This is a case from the Court of Appeal in San Francisco. The University of California had a policy prohibiting the employment of undocumented students, which was found to be unlawful on its face under California law. FEHA prevents that. However, United States Code 1324A makes it unlawful to hire a person who's not either lawfully admitted for permanent residence or authorized under federal law to work in the United States. This same code section authorizes the federal government to conduct civil and criminal enforcement proceedings against the alleged violators. But California Government Code 12940, FEHA, makes it unlawful to discriminate in hiring based on national origin and immigration status unless the employer can show by clear and convincing evidence that it's required to discriminate because of the employee's or applicant's immigration status in order to comply with federal immigration law. So here we have the university caught between state and federal law. Their position was that the university ran a risk of federal prosecution by knowingly violating federal law in their hiring practices. The petitioners believed that this particular federal law could possibly not apply to the university as a state government entity, and therefore they should not be allowed to discriminate based on a yet undetermined risk of federal prosecution. The university pointed to statements by government officials that supported their conclusion that their concerns of being prosecuted were real. Now, FEHA has a safe harbor provision where an employer is not liable for actions motivated by a desire to comply with a directive from the federal government. But this Court of Appeal found that the university did not argue that its policy was complying with a directive from the federal government. Rather, the university only argued that their analysis found a risk of being litigated against by the federal government. The Court of Appeal did not feel that the university's reason, fear of potential federal prosecution, was good enough to justify discriminatory hiring practice. The court held that a risk of harm was not a sufficient reason to justify discrimination that is specifically forbidden by California law. So the court issued a writ of mandate directing the university to reconsider its policy. The court did send some signals in its decision that the university could make different arguments. For example, that perhaps federal law might not apply to the university, and that the university could seek a declaratory judgment about the application of federal law. 17 days after this decision came down, a petition for review was filed with the Supreme Court. So we don't have a final decision. This, of course, is congruent with a lot of problems we see with preemption, with federal law conflicting with state law, with a very hot topic of immigration right now. So this is not finished. There's a petition for review, and the court instructed the university to, hey, maybe go seek declaratory judgment. So long story short, to be continued. Javier, do you have a comment?
I do, but let me ask you a difficult question first. How does this decision help employees? Does it?
As of right now, the university's policy has been found unlawful, so to speak. I put unlawful in quotes because the court just told them to reconsider their policy. So their policy of not hiring people without papers has been questioned by a court. So that would help potential employees who want to apply for a job with the university, where the university's policy of not hiring you if you're undocumented has been called into question.
I see. And the reason why I ask you this question, George, is because to me, from the perspective of defendants that I'm taking now for purposes of this presentation, this is just a distinction without a difference. It doesn't make a difference, and here's why. The policy of the university is that the university will hire only individuals with federal work authorizations. And the court concluded that that statement, because it's a blanket statement, because it applies to everybody, was taking into consideration immigration status, which is a discriminatory act under FEHA. But at the end of the day, the University of California still has to comply with the immigration law that requires for employers within 72 hours of hiring a person to validate that the person is authorized to work in the United States. So from the practical point of view, now if the policy of saying we only hire people who are authorized to work has been found to be illegal because it's too broad, a person without authorization applies for a job, they start working within 72 hours, they complete the Form I-9, and the university has to terminate their employment because they're not authorized to work in the United States because federal law says that an employer, including public entities, cannot knowingly hire people without authorization to work in the United States. So at the end of the day, it's going to be the same result. Now, I don't know what the court is going to do now with this, but from the practical point of view, I think it's important for employers to make sure that their hiring managers and the HR understands that questions about immigration are fraud and they shouldn't talk about that at all. Immigration status should be insignificant because it is when people are hired at the I-9 level, once they're completing the forms, then that conversation may happen, but not before, because California has said that under FEHA, that's dangerous. Any reply?
This
I see you shaking your head, so I have to ask.
This case reads much like a policy debate, meaning this wasn't determined so much on the factual merits as it was determined whether a policy on its face was unlawful or not. And like I said, the court gave so many indications that the university left arguments on the table. For example, the particular law at play here may possibly not be applicable to the university. They haven't explored that, and the court said, explore that. Go get a declaratory judgment. So the case did read like a policy debate and left more than two doors wide open for future decisions.
Agreed. We're going to move on now to page 4 of the materials. And on page 4, there is a case that we would like to mention. And what that means is that we're going to talk about what the court holding is and the practical implication to employers on both sides. And it's the case of Williams v. J.B. Hunt Transportation, Inc. And in that case, the court dealt with the labor court requirement when an employer pays employees on a piece rate. The basic rule is that employers have to account for all time, including non-productive time, and they have to pay productive time, or they may pay productive time at a different rate as long as they account for all non-productive time, including breaks. Kind of difficult to do, so some employers have moved away from that. What this employer did was to pay their employees for all hours at a guaranteed rate. And then in addition to that, this employer paid a production compensation or bonus. And the argument was whether that scheme, which is a hybrid scheme of paying a guaranteed amount and then an amount based on production, is it lawful? And the court said that as long as employees get at least minimum wage for absolutely every hour that they work, that hybrid system of paying is lawful under the labor code. Pretty new amendment, pretty new case, so it is important for employers that deal with piece rate to know about this case.
And the case re-emphasized that minimum wage is required even for non-productive time. And the pay stub has to call out the different rates of pay. So it has to show what's being paid at this rate, what's being paid at that rate. The decision calls the pay structure of the employer, in this case, convoluted. But in my opinion, that seems to be in response to a very convoluted Labor Code Section 226.2. It is hard to understand. So from the plaintiff's point of view, what I would say is, yes, this one was a loss, but I would keep challenging these pay structures. As a plaintiff's attorney, I would still keep going after this. Sometimes it's just the judge you get, but the convoluted nature of 226.2 still makes these types of cases right for plaintiffs.
And I agree with that analysis. It is very hard to comply with the requirements because it seems that the public policy is to discourage additional compensation for productive time. But, and on just talking to employers, some employees love it and they like it and they want to make more money if they work harder, faster, better. But the state doesn't seem to be recognizing that, at least in the piece rate arena, which is an issue and has been an issue for years. So this is to be continued, to quote George.
For sure. And this is kind of a continuation of downtown motors, where we had mechanics getting paid flag hours and then they had non-productive time. So this is a can of worms that's going to stay open for a while.
In some industries. Now, George, let's move to page 5 of the materials. And on page 5 of the materials, I'm going to talk about the case of Iloff versus LaPaille. And I hope the pronunciation is correct. But in this case, what happened was that there was a small company, and this employer decided to have a person give maintenance to the property in exchange for living at the property without paying rent. So it's essentially a bargain, a trade, a barter for this person to work, doing maintenance work, but not getting any compensation other than free rent. And this went to the Labor Commissioner's office, and the Labor Commissioner's office decided, of course, that you cannot do that people have to be paid at least minimum wage for all of the hours worked. No surprise there. However, the question is, or was, whether the employer is also responsible to pay the penalties that attach to not payment wages, liquidated damages, equivalent to an equal amount of the wages that were not paid. Does the employer have to pay that? And the decision was that in this case, liquidated damages were not appropriate because the employer simply didn't know the law. And because they didn't know the law, it was not an intentional violation. And because it was not an intentional violation, then the penalties should not attach. It made its way to the Court of Appeal and then all the way to the Supreme Court. And the Supreme Court said that ignorance is not enough. Just not knowing the law will not excuse you from paying liquidated damages, because the purpose of liquidated damages is precisely to make sure that people make an effort to comply with the law. So the question that remains then is, what is it that the employers must do to prove that liquidated damages are not applicable based on a good faith defense? And the court gives a little bit of guidance by saying, well, you may be able to demonstrate good faith if, for example, you document your diligence, right? Read an article, go to the state's agency's website, find some credible source to say that at least you tried to comply. Talk to an employment attorney. Even if the employment attorney gives you bad advice, at least you try. Or some other form of trying to comply should be documented before, of course, implementing the practice, not once the lawsuit comes or the charge with the government agency. It is important also, looking at this case, for employers to train their managers or HR on what the policies actually are. And if the employer discovers a potential violation, they should correct quickly and get it done. Because in some cases, from the defense perspective, Some managers and supervisors have heard employees bring issues to them and they don't escalate it to HR or to ownership. And sometimes the mistake is not found until after there is a lawsuit. And of course, it will be much better if something is found to correct it quickly, and that may be evidence of good faith that may prevent the imposition of liquidated damages. So that's the holding in this case. George, from the perspective of employees, what do you think?
This is a good case for plaintiffs. It's not surprising that the court found that the maintenance worker was an employee. And it's good that the Supreme Court didn't allow ignorance or a mutual misunderstanding to save the employer. I hear employers say, well, we agreed to this situation. Well, the employer has larger obligations than just getting an agreement from an employee. AB 5 and Dynamics have made it pretty clear that almost anyone who works for someone else on a regular basis is going to be considered an employee. And employers can't invoke ignorance to avoid all the implications of the labor code, including the liquidated damages. So to make the argument about willfulness, the court's just not buying it. When you're an employer in California, you have obligations.
What do you think?
Go ahead.
And I'm sorry to speak over you. So what do you think about these factors? Is this enough to show good faith?
A mutual misunderstanding, absolutely not. Does not show good faith. Good faith,
but trying to look for something, documenting it, correcting it.
The factors you mentioned. The factors you mentioned, yes, but the factors in this case, no.
Of course, and on that we agree. It's pretty brazen just to say work for free and just live here. I do want to close this conversation on this case on the subject that now that the court has said that for purposes of liquidated damages, ignorance is not enough, and that good faith has to have evidence to back it up, I think that this also applies to other penalties under the labor code. This was only dealing with liquidated damages, but there are other penalties under the labor code that may be subject to the good faith defense also. So these factors should apply to those as well.
And I'll respond briefly on that before we go to the last case. And that is that Labor Code 203 is one of the obvious implications. And good faith defense, willfulness, they all have very specific meanings. And the 226 has some of it. They all have cases that have analyzed the language of each and every one of those statutes. And those cases have really drilled down even on the differences between some of those sections. So are they similar? Yes. Can you absolutely rely on a holding with regard to 1194.2 to apply to 203? No, I think you need to do your research on those statutes separately.
I don't see why not, but we're not judges. Now, moving on to page 6 of the materials, George, I think you're going to make a mention on one of the cases there.
Yeah, a quick mention. Here we had an exempt employee. He was an outside salesperson, so he was exempt from overtime. And he complained about how he was getting compensated for sick time. Sometimes we have a blended rate, which combines your regular rate of pay and your commissions. They add it up, they divide by something, and they get a blended rate. And sometimes that blended rate is applied to things. Maybe it's applied to your overtime, for example. In this situation, the company was paying sick time at his base rate. They were not taking commissions into account to calculate the rate of pay for paid sick leave. What the court found is that under Labor Code 246, if the company is calculating other forms of paid leave, such as vacation or PTO, on this basis, on the basis of just the base rate, then they can justifiably calculate the sick time on that same basis. So the court said, no, you don't get a blended rate for your sick time. You don't get to have your commissions added into your hourly rate and divided by some number to give you a higher rate of sick pay. If your other forms of paid leave are paid at your base rate, then the company is complying with the law by paying your sick time at that base rate.
This is an interesting case because essentially what the court is saying is that if somebody is exempt, then the base rate is enough to pay, in this case, paid sick leave. However, I think the message for employers here is that if you're dealing with a non-exempt employee, of course, the regular rate of pay, which is a term of art, a legal term defined, has to consider additional compensation, including commissions. This could be the end of this argument, but the message is more important for the non-exempt people because the regular rate of pay still applies. And for exempts, now we know that at least a court has said, a court of appeals, that it is okay to pay the base rate because they're exempt, and exempt should mean something for the labor code.
But a finer point is that the court said it was okay as long as that is how you're calculating their other forms of paid leave. So that obviously implies that if the other forms of paid leave are paid on a blended rate, then you better pay them their sick pay on a blended rate as well. And the language of Labor Code 246 supports that's the comparator. What are you doing with the other forms of paid leave? It doesn't say you just get to pay base rate, period. It says you can pay base rate if that's how you pay other forms of paid leave.
Which is interesting because basic leave is statutory and mandatory. But for example, paid time off or vacation is not statutory, it's not mandatory. So the argument could be made that you could have two different rates. But I hear you. The court did mention, and it was part of the decision making, that the policy was to pay all leaves the same.
Right.
And that because the person was exempt, it is not a violation of the labor code, which requires regular rate of pay. And
the court pointed out that that's supported by the statutory language
in the interpretation. George, thank you so much. And this brings an end to this month's discussion of the cases. There are more cases on the summaries. Some are really interesting. There's some discrimination cases that are fascinating. So I invite everybody to read all of them. In the interest of time, we only discuss the ones that deal with California policy. But I want to thank George Bean today for his time and his insight. I want to thank the law firm of Payne and Fierce for preparing the summaries every month. And I want to invite you all to attend the next in-person meeting of the Labor and Employment Law Section, which is going to happen in the month of October 2025. Please visit the website for the Orange County Bar Association and register for the next meeting, and we'll see you there.